Case summary. Case name. Butler Machine Tool Company Limited v. Excello Corporation, England Limited. Court. Court of Appeal of England and Wales. Citation. 1979 1 WLR 401. 1979 1 OLE R 965. Date. 1979. Judges. Lord Danning M.R. Lawton L.J. Bridge L.J. Background facts. Claimant plaintiff, Butler Machine Tool Company Limited. Defendant, Excello Corporation, England Limited. Facts. Butler Machine Tool Company Limited, Butler, was a manufacturer of machine tools. Excello Corporation, England Limited. Excello was a company that needed a machine tool. On May 23, 1969, Butler sent Excello a quotation for the sale of a machine tool, priced at £75,535. This quotation included Butler's standard terms and conditions, which contained a price variation clause allowing for an increase in price if costs increased before delivery. Excello responded by placing an order on their own standard terms, which did not include the price variation clause and instead stated that the price was fixed. Butler replied with a letter acknowledging the order and enclosed a tear-off slip for Excello to sign in return, which Excello did. Argument. The central issue is which set of terms and conditions govern the contract. Butler argued that their terms, including the price variation clause, applied because they sent the last communication before the contract was formed. Excello argued that their terms, which did not include the price variation clause, were the ones that applied, as they had explicitly stated, a fixed price, and Butler accepted their order by acknowledging it. Final outcome and law justification. Outcome. The Court of Appeal held that the contract was governed by Excello's terms, which did not include the price variation clause. Thus, Butler was not entitled to increase the price. Legal justification. 1. Battle of the Forms. The case is a classic example of the battle of the forms, where both parties attempt to contract on their own terms. The court must decide whose terms govern the contract. 2. Acceptance and counteroffer. The court found that Excello as order constituted a counteroffer because it explicitly stated different terms from those in Butler's quotation. When Butler acknowledged this order and requested a signature, they effectively accepted Excello's terms. 3. Last shot doctrine. According to the last shot doctrine, the terms of the party who sends the final form before performance begins generally prevail. Excello's form was the last sent and agreed upon by Butler's acknowledgement. Judgment. The court concluded that Excello's terms applied, thus denying Butler the ability to enforce the price variation clause. Key concept. Implication of the case. This case highlights the complexities involved in contract formation and the importance of clearly communicating acceptance and terms. In commercial transactions, when both parties send forms with differing terms, the terms included in the final communication before the agreement is accepted will usually govern the contract. Key learnings. 1. Clear communication. Ensure that acceptance of an offer is clear and unambiguous, and specify which terms are being accepted. 2. Final agreement. The terms of the final form exchanged can determine the contract's terms, emphasizing the importance of the last shot in negotiations. 3. Contract terms. Always review and understand the terms being proposed or countered to avoid unexpected obligations or conditions. This case serves as a crucial reminder of the necessity for vigilance and precision in the contractual agreement process, particularly in the context of standard terms and conditions.